I'm going to go back to Roe because most of us look at you as the deciding vote. And I asked yesterday if your views on Roe have changed since you were in the White House. You said something to the effect that you didn't know what I meant. And we have an email that was previously marked confidential but is now public and shows that you asked about making edits to an op-ed that read the following, and I quote, "First of all, it is widely understood, accepted by legal scholars across the board, that Roe v. Wade and its progeny are the settled law of the land," end quote. You responded by saying, and I quote, "I'm not sure that all legal scholars refer to Roe as a settled law of the land at the Supreme Court level, since court can always overrule its precedent, and 3 current justices on the court would do so." This has been viewed as you saying that you don't think Roe is settled. I recognize the word said, it's what legal scholars refer to. So please, once again, tell us why you believe Roe is settled law. And if you could, do you believe it is correctly settled?
So thank you, Senator Feinstein. In that draft letter, it was referring to the views of legal scholars, and I think my comment in the email is that might be overstating the position of legal scholars, and so it wasn't a technically accurate description in the letter of what legal scholars thought. At that time, I believe Chief Justice Rehnquist and Justice Scalia were still on the court at that time, but the broader point was simply that I think it was overstating something about legal scholars, and I'm always concerned with accuracy, and I thought that was not quite accurate description of all legal scholars, because it referred to all. To your point, your broader point, Roe v. Wade is an important precedent of the Supreme Court. It's been reaffirmed many times. It was reaffirmed in Planned Parenthood versus Casey in 1992 when the court specifically considered whether to reaffirm it or whether to overturn it. In that case, in great detail, the 3-justice opinion of Justice Kennedy, Justice Souter, and Justice O'Connor went through all the factors, the stare decisis factors, analyzed those, and decided to reaffirm Roe. That makes Casey precedent on precedent. It's been relied on. Casey itself has been cited as authority in subsequent cases such as Glucksberg and other cases. So that precedent on precedent is quite important as you think about stare decisis in this context. A similar analogy, the United States versus Dickerson case in 2000, where the court considered whether to overturn Miranda versus Arizona or to reaffirm it. And in that case, the court, through Chief Justice Rehnquist, specifically reaffirmed Miranda, despite the fact that Chief Justice Rehnquist had been a critic of Miranda in his early days and had written some opinions quite critical of it. It became that, so that Dickerson case is similarly precedent on precedent, which is important going forward as you think about the stare decisis calculation for a case like Miranda. So that's why both of those cases, Planned Parenthood versus Casey and Dickerson, are cases where I would refer to them as precedent on precedent.
So you believe it's correctly settled, but is it correct law in your view?
Senator, there's on that case or on Dickerson or on cases like Citizens United or Heller or United States versus Lopez or Kelo, just the whole body of modern Supreme Court case law, I have to follow what the nominees who've been in this seat before have done.
Judge, a yes or a no will do.
Well, I'm just, if I can briefly explain.
Yes, you can.
Briefly, I'll try to be brief, but when you're in this seat, I'm not just sitting here for myself, I'm sitting here as a representative of the judiciary and the obligation to preserve the independence of the judiciary, which I know you care deeply about. And so one of the things I've done is studied very carefully what nominees have done in the past, what I've referred to as nominee precedent. And Justice Ginsburg, but really all the justices, have not given hints or forecasts or previews. And Justice Kagan, I think, captured it well, as she often does, in talking about questions like the one you're asking. You can't give a thumbs up or thumbs down and maintain the independence of the judiciary. So I need to follow that nominee precedent here.
Okay. Mr. Chairman, could I ask that the email at issue be made part of the record?
Pardon me?
I'd like to ask that the email at issue be made part of the
Yeah, we'll
record.
be happy to do that. Thank you. During your time in the Bush White House, the administration actively took steps to limit women's reproductive choices. This included reimposing the global gag rule to prevent foreign organizations from spending their own money on reproductive health, and trying to prevent the FDA from making Plan B contraception available over the counter. During your service at the White House, 2001 to 2006, did you work on any issues related to women's reproductive health or choice?
President Bush was a pro-life president, and so his policy was pro-life, and those who worked for him, therefore, had to assist him, of course, in pursuing those policies, whether they were regulatory. There was partial birth legislation that was passed as well. And some of those things might have crossed my desk. I can't remember specifics, but I think this came up in Justice Kagan's when she worked for President Clinton. He had a different view than President Bush on that issue, and she had some work for President Clinton. I consider myself working for President Bush. Was there to assist him.
Let me go to torture. During the time you worked in the White House, the Office of Legal Counsel concluded that harsh interrogation techniques were legal, even though Congress had passed a law in '94 banning torture. The Office of Legal Counsel took a sweeping view of presidential power and concluded that the president could override the statute. In response, in 2005, the Congress adopted an amendment championed by our colleague, Senator McCain, I was the co-sponsor, that stated that only interrogation techniques that can be used are those authorized in the Army Field Manual. Was the Office of Legal Counsel correct when it concluded that the president could ignore the torture ban?
So the Office of Legal Counsel, Senator, subsequently withdrew those memos, as you know. And as I've made clear in some of my writings, the review of Judge David Barron's book, some of my opinions as well, the president does not have the authority to disregard statutes passed by Congress regulating the war effort, except in certain very narrowly described circumstances that are historically rooted, the common example being command of troops in battle. So as a general proposition, the president has to comply with the law. The president is subject to the law, including in the national security context. That is the lesson, I think, of the Youngstown Steel case of Justice Jackson's categories. Category 3, as I've said repeatedly in my writings, which is where Congress has prohibited the president from doing something, is critically important. That's essential to the rule of law, as Justice Jackson said. That's the equilibrium of the country is at stake in Category 3, and I've written about that quite frequently.
Got it. Thank you. Today we have a president who said he could authorize worse than waterboarding. How would you feel about that?
Senator, I'm not going to comment on, and don't think I can, sitting here on current events.
Well, but you know what the law is. You've made that clear.
I know what the law is, Senator, and I know you're...
I asked specifically, how do you feel about that?
I feel that I should follow the law as a judge. I know what the law is, and I know your leadership on this issue, both with the report you did, which was the thorough documentation of things that happened, as well as recommendations for the future. And I know your leadership with Senator McCain on the 2005 Act as well. And I know what the law is, and I've written about how the separation of powers works when Congress passes laws of the kind that you have.
One last question on this. In December of '05, President Bush issued a signing statement regarding the Detainee Treatment Act of 2005, reserving the president's right to disregard the law's ban on torture if it interfered with his constitutional authorities as president. What was your involvement, if any, with this signing statement?
While I was staff secretary, any issue that reached the president's desk, with the exception of a few covert matters, would have crossed my desk on the way to the president's desk. I wouldn't have, in the ordinary course, provided the policy advice or the legal advice, but it would have crossed my desk. So in that case, the signing statement, the drafts of it, that process would have crossed my desk at some point.
Okay. In a 2013 panel discussion, you did nothing about it, though. It crossed your desk, and that was that.
Well, there was debate, as I think I've mentioned, about that. The counsel to the president, Ms. Myers at the time, was the ultimate advisor on that matter for the president, and thus would have been the one who primarily dealt with that with the president. It was important in the job I had there not to supplant the policy or legal advisors. That was not my job. My job was to make sure the president had the benefit of the views of his policy and legal advisors.
One more Bush-era question on this. In a 2000 panel discussion at NYU Law School regarding Bush administration anti-terrorism policies, you said the Bush administration went, quote, right up to that legal line to defend the security of the United States, end quote, implying that Bush policies did not cross the legal line. Do you mean to suggest that Bush administration's post-9/11 programs, including the CIA torture program, were legal?
No, Senator, that's not what I was suggesting there, and let me try to provide you an explanation. President Bush's view, as I think he has said publicly, was in trying to keep America safe, he was going to do everything he could within the law. He relied on his lawyers to provide him the boundaries of what the law is, and then he would go up to that line as he thought effective as a matter of policy. It was up to the lawyers, therefore, to make sure that they were giving sound advice and having the backbone, and this is something that your legislation reinforces. Lawyers need to have backbone, even in pressurized moments, to say no, and I've talked about that many times. One of the most important responsibilities of an executive branch lawyer, in the passions of the moment, where the pressure's on, where the president wants to do something perhaps, is to go into the Oval Office and say, no, you shouldn't do this. And that's something that I've written about, talked about, and experienced in my time with President Bush. And I've encouraged young lawyers to have that backbone and fortitude to say no. That's about the most important thing.
Thank you. A quick change of subject. You sat on a case where a trainer, Dawn Brancho, was killed while interacting with a killer whale during a live performance. Following her death, the Occupational Safety and Health Administration found that SeaWorld had violated workforce safety laws. The majority agreed with the agency that SeaWorld had violated the law. According to what I know, you disagreed. In your dissent, you argued that the agency lacked the authority to regulate employers to protect participants in sporting events or entertainment shows. However, the statute, as enacted, applies to each employer, and it defined employer as anyone engaged in business affecting commerce who has employees. Where in the text of the law did Congress exempt employers of animal trainers?
Thank you for the question, Senator. The first point I want to make is that was not a case that involves potential compensation to the family. That was handled through the state tort system or through insurance or through a settlement with the SeaWorld and the family. So the case before us had nothing to do with compensation to the family. It had to do with a separate regulation of SeaWorld. The issue, Senator, was precedent. I follow, as a judge, I follow precedent. The precedent of the Labor Department, as I read it, was that the Labor Department, under the statute, would not regulate what it called the intrinsic qualities of a sports or entertainment show. So lots of sports and entertainment shows have serious dangers, whether it's football or the balance beam in gymnastics or the high wire act at the circus or the lion tamer show. And the SeaWorld show was, as I saw it, of a piece under those, with that precedent that said the Labor Department would not regulate, for example, whether baseball helmets had to have ear flaps, or whether to prohibit the punt return, or to make the balance beam have nets. And this seemed to be covered by that precedent as I saw it. The Labor Department in the oral arguments tried to distinguish, for example, the dangers of football from the dangers of the SeaWorld show, and I did not, as I explained in the opinion, find that distinction persuasive. But I did make clear two things, Senator. One is Congress could, of course, regulate the intrinsic, Congress could make the decision to regulate the intrinsic qualities of sports and entertainment shows, or the Labor Department could change its precedent. And I made clear that, of course, state tort law, as the NFL has experienced with the concussion issue, state tort law always exists as a way to ensure or help ensure safety in things like the SeaWorld show.
Thank you. A question, if I may, about independent agencies. Congress has established several independent agencies. We believe they're essential to enforcing our laws and safeguarding consumers. Congress requires the president to have good cause to remove the heads of these agencies to insulate them from political interference. You have objected to this limit on the president's power and struck down the for-cause requirement in a case involving the Consumer Financial Protection Bureau. The D.C. Circuit disagreed and overturned your decision. If the president can fire the heads of independent agencies for any reason, what's to prevent political interference in these independent agencies?
Senator, I have followed the Humphreys executor precedent. I've referred to it as entrenched. That is the precedent that allows independent agencies and protects them from at-will firing, the for-cause restriction. So as a general matter, I have affirmed I've followed the precedent of Humphreys executor. The example you're talking about, the Congress established a new independent agency that did not follow the traditional model of independent agencies of having multiple members. That's all I thought was problematic there, and I did not invalidate or did not say the agency should stop operating. I said the agency can continue performing its important functions on behalf of consumers, but either it had to be restructured as a multi-member agency or the president had to be able to remove the single head at will.
The limited set of documents we've received indicates that you were heavily involved in the Bush White House's response to congressional investigations after the Enron scandal. Is that accurate?
That is accurate. We had a document request from Senator Lieberman's committee, and I was one of the lawyers that had to help gather the documents from people within the White House and then had to negotiate documents. I had to negotiate documents with Senator Lieberman's staff.
Right. So you know that Enron was one of the greatest corporate scandals in American history. And I can tell you, as a senator from California, not only did many of my constituents lose everything financially when Enron collapsed under the weight of its accounting fraud, but the fraud and market manipulation contributed to an energy crisis in California. White House emails show that you were asked to review a set of draft talking points for Press Secretary Ari Fleischer that address the role of Enron's market manipulation in the California energy crisis. Essentially, the talking point said if there was any misconduct by Enron, it was up to the Federal Energy Regulatory Commission to investigate and punish the company. I'm not going to ask you if you remember this specific document, but was that your view, that FERC was the regulatory body that was supposed to stop this sort of misconduct?
I'm not recalling the specifics of that, Senator. My role as a general matter was to help gather documents in response to Senator Lieberman's committee's requests, as I recall. And I know FERC would have a role necessarily in something like that, but I don't know if I thought primary, or I don't think that was my area of expertise, so I'm just not recalling it specifically, Senator.